the legal battle over the immigration status of former Miss South Africa finalist and Miss Universe Nigeria, Chidimma Adetshina, is set to return to the Cape Town Regional Court on Wednesday, 19 August, where the court is expected to hand down judgment on her bid to halt her deportation. The state argues that Adetshina does not have the necessary documentation to remain in South Africa and that detention and deportation are justified, while her defense has proposed alternatives, including regular reporting to an immigration officer. So, what are the key legal issues the court will have to consider, and what could the judgment mean for Adetshina's future in South Africa? We are joined by Craig Smith, immigration lawyer, to unpack the case. Craig, good afternoon to you. So let me just give you the basic outline in terms of what some of us understand the case to be. She was later discovered to have been in South Africa as a result of her mother obtaining illegal documentation, and people that support her tell us that it was not her fault. But to fast forward the issue, she then chose Nigeria, and she participated in a world pageant representing Nigeria, connected with her family in Nigeria, and then she was back. She was seen in Cape Town, and then bringing us to where we are today. So how is the court going to make a determination? Because some people argue that the fact that she was born in South Africa because she cannot be faulted for her mother's faults or her mother's conduct in obtaining illegal documentation, and therefore some are saying that on that particular technicality, she has a right to come back to South Africa and be a permanent resident or citizen.
Yeah, thank you for having me. I think the big issue here is it's not just any documentation she obtained. It was effectively South African citizenship and a South African passport, which is really the highest status you can have in South Africa. And that was procured by her mother, who was a Mozambique national, who sadly forged Miss Chidimma's birth certificate. So on the face of it, it looked like she was a South African citizen by birth. That obviously came to the fore in rather unfortunate circumstances in the Miss SA finalist competition, because they then ascertained that her South African citizenship may not be regular, and they then dealt with that. That's when Miss Chidimma then took on her Nigerian nationality, which basically put pay to her efforts to try and argue she's still a South African citizen. So she was correctly revoked or deprived of her citizenship by the minister. For once, Home Affairs are correct. And the minister is quite justified to revoke her South African citizenship. What she then did is she tried to get back into the country by misrepresenting her South African citizenship status, got back in. Home Affairs then found her and then sought to detain and deport her. The matter before the Magistrate's Court is now due for judgment, which deals with her deportation, which is all emanating from that whole citizenship furor. The Magistrate's Court, however, does not have any power to issue a deportation order. That is only the domain of under the Immigration Act and the Minister of Home Affairs. So I don't think a magistrate's empowered to issue the deportation. So I think the judgment is going to be a bit of a damp squid. What Ms. Chidimma does have, though, is when a deportation order is issued, you're entitled to appeal. And then subject to the outcome of the appeals, you can still go to the court and review. So she's entitled to be here. She has legal representation. So she will be here as long as the court process takes to finalize her deportation, but not the Magistrate's Court in this case.
Am I hearing you, Craig, to be saying that the case this week on Wednesday is not as big as some of us have made it out to be?
No, and it's because the Immigration Act is clearly set out, which is obviously an act of Parliament, which does not empower or authorize the magistrate to issue a deportation. It only allows a magistrate to determine the detention, the lawfulness of a detention in the event that Home Affairs seeks to detain a foreign person. but they cannot go to the next level of a deportation. Sadly, that emanated from our NPA and the Department of Justice, who sent a circular around to all magistrates' courts to say if they impose a sentence on under an Immigration Act, a criminal charge, they must, in addition to imposing a sentence relating to the charge, issue a notice of deportation. But our courts in the Western Cape, whilst it's a matter of time, a case I recently did, the courts have frowned on. It was a decision in Gauteng, which they would say is wrongly decided. So the magistrate in this case is not empowered, and that emanates from the Department of Justice, who sent a circular to magistrates, but it is incorrect.
So once again, just for me to get clarity, so what the court is likely to decide on Wednesday is whether to keep her or get her into custody in terms of the charge, or for her, as proposed by her lawyers, to report to an immigration officer periodically.
So what you have is what Ms. Chidimma did, I suppose, as a last recourse, is to challenge the citizenship matter and her deprivation. I think they're on a hiding to nothing. I think Home Affairs are correct. But what they would probably seek to have is to have her remain in South Africa pending the review of her citizenship. Where she was previously considered a citizen by birth as a result of fraudulent misrepresentation, her lawyers are now trying to challenge and say, well, she could become a citizen by naturalization because she was here from birth till 18. But that's not going to cut it. So in that citizenship case, in the High Court, they would seek that she remains here. But the court, the magistrates' court, are out of their terrain, out of their depth. So they literally have to rely on the High Court to give direction on that.
After all is said and done, I suppose, as you indicated, this is going to be quite a process which may be prolonged. But where do you think it will end? Because at the end is expected. But where do you see the direction with regards to where this is likely to end? Will she be declared a South African citizen or given a right to be in the country? Or do you think that the Home Affairs Department will emerge as winners here?
I think that Home Affairs will emerge. It'll take time because they will proceed through the High Court. If they turn down, she can take the matter to the Supreme Court of Appeal. But at the end of the day, you can't get citizenship through an alternative means. You're either a citizen by birth, which would have been if everything was above board, but it wasn't. But to then try a circuitous route to say, I'm now a citizen by naturalization, which is where you say you were a resident or you're here from birth till 18, is not going to cut it. And the minister in this case is justified. And, you know, the department do have a tough job and they have to set a precedent. So both on the citizenship, I think she's going to go down. And on the deportation, I mean, the Home Affairs must be entitled to, they have the right to deport, but it must be done lawfully. Ironically, we've seen most recently where they deported Ghanaians, Nigerians, and everyone else in a mass deportation. That was horrendous. And now they're seeking to recover 300 million rand through the repatriation costs. So I think in this case, you know, Ms. Chidimma is going to face the wrath of the law, and correctly so in this instance. But she does have the right to challenge these decisions. But this is not really for the magistrate court to enter the fray, because they've already done what they were meant to do and rule on the detention alone.
As an immigration lawyer in South Africa, I mean, what can you give us a sense of how common such like cases are?
Well, it depends which one you're talking about, because there's two lanes. There's the citizenship lane, and that is where you can become a citizen through birth, where a parent may be a citizen or a permanent resident. You can become a birth through, you get citizenship through descent, where that's an adoption issue, and naturalization, which is commonplace, where you have permanent residence for 5 years and you can seek then citizenship through naturalization. They're all equally the same. But that's citizenship. What happens very commonplace is where people are in the country irregularly and they are arrested by Home Affairs, whether it's through raids or just bad luck, and they get arrested, and then Home Affairs seeks to not only detain and deport. And there's a wealth of case law that, in as much as you want to, you have the right, Home Affairs have the right to detain and deport, arrest, detain and deport. You know, the detained person, still foreign person, still has the right to challenge the deportation, because the arrest, firstly, is presumptively unlawful, and a deportation carries a right of appeal. But this is a common day occurrence where people are arrested and deported. And what we've recently seen, in which got a lot of traction, a lot of noise, were mass deportations. So, ironically, Ms. Chidimma is getting, you know, a lot of attention. Yet the masses, whether the Malawians, Zimbabweans, Ghanaians, Nigerians, were just you know, crawled together and deported, regardless of whether women were pregnant or whether children were being separated, or regardless of the circumstance. So it is unfortunate that this matter has special attention, because I don't really think it should. I think the focus should be on those mass deportations, because that's abhorrent.
Well, Craig, thank you very much for joining us on this particular discussion, and we really appreciate your time and your insights. Craig Smith, immigration lawyer, unpacking the Chidimma case.